will be Amanda's. And then we'll get Brown up there as soon as we take.
Right, who's up first?
Mr. Gamble with Tracy McGee.
CR 2183, set for pretrial.
Judge, we have reached an agreement with the state, and we can set Ms. McGee on the next available plea date.
Is it going to be a plea for probation or time?
Probation.
So is it going to be an amendment, or is she going to be pleading true and being continued? What's the?
This is a brand new case, Your Honor.
It's a brand new case.
I believe so. This was indicted March 30th of this year.
Is she any time or anything as a condition of probation?
That was not a part of our offer, no, Judge.
Okay, I'm just trying to determine whether or not we should give her some type of PR bond or something to let her out before, rather than holding her over for several weeks. If she's going to be placed on probation, to do something today rather than wait.
That would be fantastic.
State have a position on that? The next time I could get her in is going to be July 27th. And so that's another 2 weeks of having her housed in the jail.
And she is currently being housed in Henderson County, Your Honor.
Judge, I think the state would not oppose Ms. McGee receiving a bond today. I would caution the court. I believe the reason she's in jail is while on pretrial release, she tested positive for meth. But I don't think that the state would, at this point, oppose a personal bond. We just can't recommend one.
No, I understand. But if the paperwork was done today, she'd be on probation today, and we'd have that.
That is true, Your Honor. Yes, Your Honor. That's why I'm saying I'm not opposed to it. I just can't recommend one.
And Mr. Gamble would be sad if the court grants her a personal bond today to let her out of jail and sets her for a plea, and then finds out that she uses drugs between that time, this time, and that time, because then the court could reject the plea and set her for trial. Wouldn't you agree that'd be sad, Mr. Gamble?
I don't believe that'll happen, Your Honor.
But if it did, wouldn't that be very unfortunate for Ms. McGee?
That would be okay.
You understand what I'm telling you, Ms. McGee?
Yeah.
I'm telling you that if I let you out today and I drug test you when you come back to court, you have anything I'm going to reject the probation plea. Listen to me. I'm going to reject the probation plea. There will be no surprises. I will reject the probation plea, and you will go back into custody, and you will sit there. You have a trial. You understand?
I got you. I will not do this. I'm good with this.
All right, the court will set Ms. McGee for plea on July 27th. Can you make it on that day, Mr. Gamble?
And will that be at 9 in the morning?
That'll be at 9 a.m. Are you available that day, Mr. Gamble?
Yes, I am.
Okay. And the court is going to grant Ms. McGahee a personal bond on the condition that she is still on all conditions of pretrial release, and will enter her probation. The only reason I'm giving you this is because the state's recommending probation. If they were not recommending probation, we would not be doing this.
Okay. And I want what you said. I'm not gonna get it.
I will have a personal bond order sent over later today to the jail.
Thank you.
All right, we'll see you back on the 27th. Don't screw it up.
I won't screw it up. I promise you that.
And Your Honor, that's all I have this afternoon. Can I be excused?
Yes, sir.
Yes, sir. Thank you, Mr. Gimbel.
Ms. Beasley's ready on the plea on Montana Tippett.
Okay. CR 2317 State versus Montana, Ray Tippett. Mr. Tippett, if you'll raise your right hand, I'm going to place you under oath. Mr. Tippett, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Tippett, you can put your hand down. Mr. Tippett, are you pleased with Ms. Beasley as your attorney in this case?
Very much, sir.
Have you discussed the case with her and feel confident that you understand everything that you've read and signed today?
Yes, sir.
And did you, when you signed the documents, you only signed once you were confident that you knew what you were signing and that is your true and correct signature, is that right?
Yes, sir.
Ms. Beasley, does your client waive the formal reading of the state's motion to revoke in this case?
He does, Your Honor. He wishes to enter a plea of true to all counts in the motion.
And you believe him to be competent today?
Most definitely, Your Honor.
All right, Mr. Tippett, you were placed on community supervision February 11th of this year. I heard evidence regarding your possession of controlled substance in penalty group 1. Upon reviewing the evidence, I followed the plea agreement you reached with the state. I assessed your punishment at 2 years confinement in the state jail division of TDC. And then I suspended that sentence at 2 years and placed you on community supervision for a period of 3 years and ordered you to pay a $1,500 fine. It was during the term of your community supervision that the state filed its motion to revoke. And the state has alleged in 5 separate counts of various ways that you violated the conditions of your community supervision. At this time, I'm going to ask you, Mr. Tippett, how do you plead to counts 1, 2, 3, 4, and 5 in the state's motion? Are those counts true or not true?
Sure.
And are you telling me that those are true because in fact they are true?
Yes, sir.
And anyone threatened, forced, or pressured you to plead true to any of those counts?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Is there any objection to State's Exhibit 1 or State's Exhibit A, the defendant's waiver of rights and plea of true to State's motion to revoke?
No, Your Honor.
All right, State's Exhibit A is admitted into evidence. Court takes judicial notice of the defendant's judicial confession. What are the terms of the plea agreement?
Your Honor, the terms are basically 1 year state jail to be served on the state jail offenses before the court on the revocation, plus money owed, which is, he still owes $1,500 on the fine, $425 on the court costs, 0 reimbursement fees, and he has 108 days back time credit. Judge, in addition to this case, the state has agreed to 1245, an unindicted theft case that was a 3rd-degree felony from $30,000 to $150,000. Offense date is November the 2nd, 2020. It's a charge arising out of Precinct 4 Constable's office. The state's agreed that the restitution of $30,000 be paid joint and several with co-defendants from this theft case, Russell Melton and Jonathan Stanberry.
And the restitution amount is $30,000 even?
That is correct, Judge.
And you said joint and several with Russell Melton and what was the first name of the Stanberry character?
Jonathan. Just let the court know, we just found out about the theft case, my client and I, 2 days ago. The DAs have not received any of the paperwork or police report discovery information on that case. However, Ms. Curry explained the case and asked me to call and talk with Keltner on it. I was able to talk to Keltner, get a lot of the specific information on the case, including photos involving the truck that was involved, also photos of a black jacket and some other items involved in this case, and who the witnesses would be on the case. And I went back to my client. We discussed that and were able to get this case worked out today before the DAs ever received formally the paperwork on the theft case.
Is there a case number assigned to that theft?
I don't think at this time there is, Judge. That's why we had to be specific in the 1245 to say it's coming from precinct 4 and it's a theft case. And the date of offense was November the 2nd, 2020, and who the co-defendants are.
And what was the alleged date of offense, Ms. Beasley?
November the 2nd of 2020, Judge.
Okay. All right, and Ms. Beasley or someone for the state, can you give me some of the facts to support the 1245? I believe I'll need that if I'm going to order restitution in that case, rather than 1245.
Okay. It's my understanding, Your Honor, that there were a group of several people that had stolen a truck from Landmark Nursery in this county. My client was not one of those that actually stole the truck. However, evidence shows that he traded some drugs and another vehicle, an 06 Pontiac, for the truck, that one of the trucks that had been stolen. The people that actually took the truck stole one truck that's a commercial truck, that's a dually truck flatbed that nurseries use to put the heavy weighted items on the back of it to move them around. And apparently the people that stole the truck the first night went back the second night and stole an identical truck from that location. Both of the vehicles had not been off the dealership. They had just recently purchased the trucks like 5 days before the theft. So they didn't have even, they still had the paper tags on them. My client and some other people were involved with, after they made the exchange or the deal for the truck, ended up spray painting the white truck black with black spray paint, tried to tamper with the GPS on the truck, and it locked it down, so they couldn't use it anymore. And at some point in time, they also did some damage to the truck. So basically the truck is considered to be total. And the state and I agreed, Ms. Curry and I agreed on the restitution amount yesterday.
Okay. All right, based on the evidence and the state's recommendation, the court will follow the plea agreement. Court hereby finds that Montana Ray Tippett has violated the terms and conditions of his community supervision. Court will revoke his community supervision, will sentence him to 12 months confinement in the state jail division of TDC. Court will award him credit for the time that he has spent in jail at 108 days. order him to pay the balance of his financial obligations. Court will bar the prosecution under section 1245 of the alleged theft offense occurring on or about November 2nd, 2020. In Precinct 4, court will order restitution in this case that is derived from the alleged theft offense at $30,000. We'll order Mr. Tippett to pay that joint and several with potential co-defendants Russell Melton and Jonathan Stanberry. Mr. Tippett, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. And I'm sure Ms. Beasley's already discussed this with you, but if Mr. Russell Melton or Mr. Jonathan Stanberry are not charged with any kind of offense, or the state decides they're not going forward on their case, you understand that you're responsible for the entire amount of restitution, whether you stole the truck or not. You understand that?
Yes, sir.
If they are criminally indicted for that case, and they're also ordered to pay restitution, then if they never pay anything and they just go straight to prison, then you're still responsible for that entire amount. You understand that?
Yes, sir.
Okay. All right, Mr. Tippett, I'm gonna have you go with the deputy to be fingerprinted when you get out of prison. I'm gonna order you to report to the courthouse to meet with the compliance officer so you can make arrangements to start paying on your fines, court costs, and restitution.
Yes, sir.
Have you excused, Your Honor?
Yes, thank you, Ms. Beasley.
Your Honor, Richard Smith is ready with Ronald Brown.
CR 19-8, CR 21-14, State versus Ronald Franklin Brown. Motion to revoke and arraignment.
That's correct, Judge.
Go ahead, sir.
I think it was appointed last week. I was out of state. I haven't received any of the evidence as of yet, and we haven't seen the indictment. We're prepared to move forward on the arraignment if the court would put that up there.
All right, give me just 1 second. Is any of that obstructed, Mr. Schmidt?
No, we can see it, Judge.
Okay.
And Judge, Mr. Brown's name is spelled correctly. You understand what he's been charged with. We'll wait for him reading, enter a plea of not guilty as to be set for pre-trial.
All right, court will enter Mr. Brown's plea of not guilty into the record, CR 21-14. Court will set Mr. Brown for pre-trial, and in CR 19-8, court will set Mr. Brown on his motion to revoke. Do you want these sooner or later, Mr. Schmidt? I know we've set you up for August and also September.
August 10th is good, Judge, if that's still open.
Yeah, I think we still have, we're filling up on that date, but I think we still have a little bit of room. So we'll set you on August 10th.
Thank you, sir. That's all I have. May we be excused?
Yes, sir. Thank you.
Your Honor, it'll be just a minute or two.
Okay.
an invitation.
Yeah, I told them.
Okay.
They're- Your Honor.
He just, I thought it was just staring off.
No, I think I see his mouth moving.
Yeah, he's definitely talking.
What are y'all doing? You look like you're over here causing trouble.
No, we were laughing at you.
I know, as you likely should.
In all fairness, we didn't tell him it would be 2 minutes. Yes, come on.
We're ready on Matthew
All right, is
Grace.
this Matthew Grace?
Yes, sir.
Yeah,
All right,
yes, Your Honor.
CR 2167, State versus Grace, we're set for docket call today.
Yes, Your Honor. I don't know that we covered this last time, but Mr. Grace has a couple of issues in another county that I've been trying to resolve and have not been able to. So at this time, we're gonna move it to pretrial, and I wanna work with either Mr. Woodwhite or someone else in the district attorney's office to come to some sort of resolution, but if we don't, then we are asking just to go to the trial docket at this time.
Judge, state has no objection to moving to a final docket call at Ms. Payne's convenience, so we can attempt to work this out. I believe this is our second docket call. If we could have one more and try to work this out in conjunction with Mr. Grace's other cases, state is comfortable with that.
Ms. Payne, do you represent Mr. Grace in the other county?
I do not. I've been trying to reach the attorney of record in Dallas, and she has not returned my call, but it's possible that that I've been misinformed and what I've seen online is not correct. So I'm gonna work with Mr. Grace to find out what we can do about that today before I leave.
What other charge does he have in Dallas County?
He has a forgery of a financial instrument that appears to be unindicted or unfiled as a misdemeanor, but is also still filed as a felony. And the whole thing is really confusing, and that's why I wanted to talk to the other lawyer. And there's possibly an issue in Tarrant County as well, but I couldn't find anything online about that.
Okay, we'll set Mr. Grace then for a final docket call. I don't want to set it very far out, and I don't want him just sitting and waiting in the jail. So let's, are you available on August 12th or 24th?
I'll do August the 12th, Your Honor.
Okay, we'll set Mr. Grace for a final docket call on August 12th, and hopefully you'll have a chance to speak with the other attorney, and we can have some kind of either plea announcement on the 12th, or we can set him for trial.
Thank you, Your Honor.
You're welcome.
May we be excused?
Yes, ma'am.
Thank you.
Okay, we're down to Brian Smith that's supposed to be here at 2:30, and then Bill Stevens said it would be about 3:30. And that's the last two.
Okay, do we have any other inmates we don't have any other inmates in the courtroom there? Is that right?
No,
Just Mr. Grace.
Just Mr. Grace.
Okay.
Okay.
Patty, so I'm going to invite you to a breakout room. So just hit join and create it real quick.
Everything that I want is denied. Presented denied.
No, that's fine.